Yes.
2 of 24. For the last 1 year, this matter could not be taken up for one or the other reasons. My lord, we had a talk with the AG also. AG also has given his consent to take up the matter tomorrow, if your lordship permit. The matter pertains to a gentleman occupying 2 offices in the council, Chakma Autonomous District Council, and member of Legislative Assembly in Mizoram.
We can have it tomorrow. All right, we'll have it tomorrow.
My lord. Give the mention.
Adjournment request, if any.
May it please your lordship.
Yes.
I beg to mention item number 9, lordship.
Item number 9. Yes.
Lordship, I am appealing on behalf of Mr. H. Gupta for the appellants, lordship, in this matter. Lordship, Mr. H. Gupta is not presently in station, lordship. This matter may be taken up next Tuesday, my lord, if your lordship permits.
These are important matters, no? Can you not address the court? Can you address virtually? You know, these are matters which are continuing for long, and we would like
Lordship.
it to be disposed of.
Lordship,
These are
these
small
out
matters.
of station since 31st of last month, lordship. Thursday, lordship, if lordship permits, Thursday.
Thursday would not be a correct day for us. Anyway, Thursday को रखते हैं सुबह for a day or two. This is a simple matter. Section 28 and section 23.
He's saying that if it's 28 is there, 34 cannot be had. But I don't find it.
Thursday.
Your Worship,
But these will be the 1 or 2 cases.
Lordship.
if I may submit, Your Worship.
Well, item number 8 and 9, Well, item number 8 and 9, madam.
Your Worship, in item 9,
Something like marriage hall where they might, you know.
in item 9, Your Worship, Honorable Justice
My
Nelson
lord.
cannot take up the matter. So Thursday won't be appropriate.
We'll be there. We'll be there.
Okay.
I'll be there.
Okay.
This bench would be there.
Then it's okay, Your Worship.
All right.
Well, item no-
Otherwise, see, if we are not able to take it up, spills over for another day, where we'll have another bench. All right. Come
Thursday.
prepared.
Thursday, Your Worship.
Well, item number 8,
Lots of place, madam.
Yes, 8.
8 and 9, madam. I am for 8, 9, madam.
You mean 9 and 10?
9 and 10 are analogous. Are you mentioning
Content, yes, madam. Yes, madam. 9 and 10, madam.
9 and 10.
Sorry, madam.
9 and 10? All right, on Thursday.
Yes, madam.
All right. Yes. Any other motion?
For admission, item number 1.
Yes.
May it please your lordship. Your lordship, this is a state appeal against the judgment and order dated 26/3/2024 in WPC number 21 of 2024,
Yes.
passed by the learned single judge of this honorable court. And your lordship, in that judgment and order, the state government will directed to refund the cess, 15% cess deducted from the compensation award.
That's right. So you argue your case. I mean,
Yes.
why that's not sustainable?
Yes, your lordship. In my submission is that the deduction was made.
He's for the government.
I know. Yes.
The deduction was made as per the Amendment Act 2022. And in that regard, your lordship, what I would like to mention is that the amendment of 2022.
That's right. We are aware of the amendment
Yes.
which took place in 2022
22.
with a retrospective date of 22/9.
No, your
23/9.
lordship. 22/9 is for the notification to clarify the section.
No. This was with retrospective effect. I mean, that section, all right. The notification by the Mizoram government.
Yes, your
In,
lordship.
under section 45A4.
Yes.
That is with retrospective effect. Let's see, where is the page?
That is in page 103.
Now at page 99 we have the
99 is the amendment.
notification. We have the amendment of 2022 in the Act
Exactly.
of 2013, and then
And another notification.
just a minute. Now, pursuant to the powers under 75A4, which you will find at page 102, the government of Mizoram may notify such acts under which acquisition made would be subject to such collection of cess. Now this notification comes retrospectively with effect from 23/9/2022. That's what we were talking.
Exactly.
From the date when the amendment under 2022 was made.
Exactly.
Right. You have a ground there. But now you'll have to explain, these lands were acquired in the year 2021. Now, would that date would be relevant, or the date when the award under 3G was made?
Yes,
Which would be the
exactly.
relevant date?
Yes.
You take a seat.
Your Lordship, in that regard, what I would like to mention is that the amendment of 2022, the amendment is a clarificatory amendment. And in the settled proposition that...
Have you understood the question of the bench?
Yes, Your Lordship, I understood.
See, the cess was directed to be refunded
Yes.
primarily on the ground that this notification, this amendment is post the acquisition.
Yes, Your
Your
Lordship.
case is, now kindly listen to the question, try and understand, then only you can answer. There is a very little catch there, a very little point which you will have to argue. I don't know whether you are prepared for this. Now the acquisition under the acquisition of land under 2013 or under some other act for railways or for north, the acquisition took place in 2021,
Yes.
right?
Yes, exactly.
The award was announced in 2023 post this amendment.
Yes, Your Lordship.
Now which date would be relevant, the acquisition or the award? And therefore the decision in this appeal would hinge on that.
Yes, Your Lordship. I understand your question, Your Lordship. In that regard, what I would like to say is that under
Clarificatory
3D
and all we have understood. We have
Yes.
seen the notification.
And my only submission is that, Your Lordship, in that amendment act, the amendment, the clarificatory amendment, the Supreme Court, the Honorable Supreme Court has settled that it has to be operates retrospectively. And in that regard, I have a citation.
Retrospectively is the date from 23/9/2022.
And
I am
Your
talking
Lordship,
of something else.
this
This
notification-
is a government appeal.
Yes, Your Lordship. And this
Can you
notification-
ask the Advocate General to be here? No, he's not understanding. There's a very little catch. We would otherwise interfere with this judgment if you satisfy us on this, that whether this amendment, even if taken with retrospective effect, because retrospectivity of a legislation is understandable even when it is not stated. Here it has been declared to be so. Correct?
Your
Now
Lordship-
what would be the relevant date? Now for that, I think it says, now come to page 101. Now insertion of a new section 75A, share of the acquisition. In case of acquisition of land covered by house pass or stale, so and so validity has not expired, then seat number 2, out of the land value paid under subsection 1 of 15% share. So this therefore can be extended or can be widened for interpretation purposes and be read that this is to apply from a date which shall be reckonable from the date of issuance of the award under 3G. But that's an argument which we have provided to you.
Look at 5.
5 is share of government shall also be deducted, not award not yet pronounced, even if notification for acquisition was issued under any land. It's not yet pronounced.
This has to be clarified.
This has to be clarified. Yes,
Yes, Your Lordship.
I don't think you are answering our question because you may not have anticipated this question.
And my submission is that being a clarificatory amendment, Your Lordship,
Take it
it
up.
has to be operates retrospectively.
We'll ask the Advocate General to appear. We'll ask the Advocate General. You have done your part. We will ask the Advocate General to appear in this matter.
Yes, Your Lordship.
We have heard so and so for the appellant and so for the respondent. The Mizoram Land Revenue Act of 2013 was amended by Mizoram Land Revenue (Amendment Act of 2022), which was notified on 22/9/2022 and published in the Gazette on 23/9/2022. By virtue of that amendment in the Act, a new section, namely section 75A, was inserted, which provided that the share of government on acquisition of land in case of acquisition covered by house pass or stall pass or shop pass or periodic patta or land lease, in which the pass holder have a temporary right, title, interest, possession of the land held, for the purpose of the union and state crops and building damage, compensation as well as land value may be assessed and be paid by the concerned collector of the district or the concerned competent authority for land acquisition as the case may be, provided that the validity of the tenure of the said land holding has not expired. Subsection 2 of 75A, which is crucial for deciding this case, is that out of the land value paid under subsection 1, the 15% share of the government shall be deducted by the district collector or the competent authority for land acquisition as the case may be, who shall remit to the state government account as revenue. Subclause 4 of the newly amended 75A provides that the government of Mizoram may notify such acts under which acquisition made would be subject to such collection of share. First up. Subsection 5 further delineates that the share of the government shall also be deducted from the award not yet pronounced, even if notification for the acquisition was issued under any land acquisition act by the union or state. First up. Armed with the power conferred on the state government under 75A4, the government of Mizoram notified retrospectively with effect from 23/9/2022 that 15% share of the government as stipulated under subsection 1 and 2 of section 75A of the amending act of 2022 shall be collected from land acquisition made by the listed authorities, and that the share of the government so collected shall be utilized for the purposes of land administration and other ancillary purposes as stipulated under subsection 3 of section 75A of the Act. The learned single judge, the respondents had periodic patta allotted to them by the Land Revenue and Settlement Department of Government of Mizoram in Saitual district, which was acquired for construction of National Highway 102B under the provision of National Highway Act 1956, for which notifications were issued in the year 2021. Thereafter, 3G estimate/award was made by the competent authority of land acquisition, hereinafter called CALA, Saitual district on 17/2/2023, and the amount of compensation assessed by the CALA was notified, but in such notification it appeared that 15% cess was deducted on the value of land, which was alleged to be illegally deducted by the appellants, despite the fact that there was no provision for deduction of 15% from the compensation amount either under the National Highways Act 1956 or the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act of 2023, hereinafter called as Act of 2023. First, the lands of the respondents were acquired under the NH Act of 1956, which is one of the enactments specified in the 4th schedule to the Act of 2013, and therefore the provisions of the Act of 2013 shall apply to the determination of compensation in accordance with the 1st schedule, and also for rehabilitation and resettlement in accordance with 2nd schedule. First, this is mandated under the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement (Removal of Difficulties) Order 2015. The contention of the respondents was that 15% cess was deductible from the compensation award by virtue of insertion of 75A4 of the amended Act of 2022, and the notification of the Mizoram government invoking the powers under subclause 4 of 75A4 of the amended Act of 2022, but then the same would not apply to the case of the respondents for the reason of the acquisition having been made much before the amendment came into existence. The appellants argue that the compensation was paid, the award was made post the amendment, and therefore if the amended Act of 2022, especially 75A, is perused, it would apply to any transaction made after 22/9/2023, the cut-off date. A special notice of this court has been drawn by the learned counsel appearing for the appellant state to subsection 5 of 75A, that the share of the government (15%) shall also be deducted from award not yet pronounced, even if notification for acquisition was issued under any land acquisition act by the union or the state. This therefore, it has been argued, makes it very clear that the amended act and the notification thereafter would squarely apply to the case of the respondents, even though the acquisition was made in the year 2021, but the award under 3G was pronounced post the amendment, that is post 23/9/2022. It appears that the learned single judge while dealing with the matter relied on the provisions contained in the Mizoram Land Revenue Rules of 2013, which was amended by Mizoram Land Revenue Amendment Rules 2019, and the judgment of this court delivered in WPC number 36 of 2021, bracket N. Van Langka and 10 others versus State of Mizoram and 4 others. And in WPC number 1 of 2024, bracket C. Lalan Zongwawa and 12 others versus State of Mizoram and 5 others, directed that since deductions made by the appellants herein towards cess was not sustainable, and therefore the appellants would be under an obligation to refund the cess amount deducted from the respondents bracket writ petitioners as per their respective shares indicated in the award within a period of 3 months. First up, the contention on behalf of the appellant / state is that the amended Act of 2022 and the notification issued by the government of Mizoram was not appropriately appreciated by the learned single judge. There is force in the submission of the learned counsel for the appellant. First up, by virtue of the amended Act of 2022, incorporating 17A in the parent Act of 2013, and the notification of the Mizoram government issued with retrospective date, even though the acquisition was made in the year 2021, and the awards were declared, the cess of 15% would be. I'm so sorry, I did not hear you. So sorry. Yes, we tried to argue for you, but then ultimately decided. Yes, what do you have to say?
My Lord, yes, I have 2 main points.
Yes.
In the year 2021, the notification was not only issued, but possession of the land had already been taken away on 15/11/2021. Our lands has been snatched away from our possession by the central government, free from all encumbrances. So our lands have been deprived from our possession in gross violation of Article 300A of the Constitution of India. So, my Lord, the new law, the amended act, should not apply to the present case because our property have been taken away
Yeah, what do you say?
in illegal and unconstitutional manner.
Even then,
Whether the acquisition was completed, that is the only
even then, and look at the new law, and this has not been challenged.
After publication of Section 3A notification, Section 3D notification was issued, declaring that the lands vest absolutely in the
Yes,
central government.
Even otherwise, therefore we read that portion, 75A, subclause 5,
My Lord,
and the notification of the Mizoram government under 75A4. That makes it very clear that if it has not been paid to you,
but my
it shall
Lord,
be.
yes, preparation and making of 3G award was delayed by the state government in its intention to in its intention to collect the 15% cess, my Lord.
Just ask when the cost, the value, the pronunciation of the award, when was it made?
Award was made in 2023 post, but he says that it is because of the difference. What have I said?
And my Lord, the second point, my Lord, WPC number 1 of 2024, that judgment was made to cover the present case, my Lord. then the state government has refunded all the 15% cess in compliance with the judgment of this Honorable Court in WPC number 1 of 2024.
We are very sorry to say, I mean, you're losing out on money, but then the law is like that. Take on. What did I say? Would be deductible. First up, it is also submitted. It is also to be noticed that the 3G award was published on 17/2/2023, that is post the amendment and the notification of the Mizoram government. First up, the Learned Council for the respondents (writ petitioners) has, however, submitted that the crucial date would be the date of acquisition, which is prior to the insertion of 75A,
My
and
Lord,
that
particularly 15/11/2021,
That's
on
right.
which date possession of the land was
that's,
taken over.
and that possession of the land also was taken, and it was because of the delay on the part of the state that the 3G award was published after the insertion of 75A in the Act of 2013 by virtue of amending Act of 2022. This, we are afraid, would not prevent the state from deducting its share for the purposes of utilizing it for land administration and other ancillary purposes, because the notification and the amendment, and because the notification is pursuant to the amendment, whose amendment, the validity of which has been upheld by this court by judgment dated.
75 has not been challenged.
No, it has been challenged. It has been challenged. Has been
75
My
has
Lord,
not been
it
challenged.
has
My Lord, that is the old
it has
law.
been Justice Ajit Singh's
No, that is
judgment.
different. Our
Acha.
75 has not been challenged.
Acha, it has not
That
been
was
challenged.
47.
Okay. So, which has the validity of which has not yet been challenged. The validity of which has not yet been challenged. First up, 75A clarifies that the share of the government shall also be deducted from the award not yet pronounced, even if notification for acquisition was issued under any land acquisition act by the union or the state. First up, with the provision contained in section 75A5 couched in such wide terms, the publication of the award post the amendment would definitely be covered. First up, for such reasons, we are not in agreement with the opinion rendered by the learned single judge directing the state to refund 15% cess collected to the respondents to their respective shares. First up, we set aside the judgment and order of the learned single judge and allow this appeal. The appeal stands allowed to the extent indicated above.
Deeply obliged.
You only pointed out number 5, otherwise I would have adjourned it for a matter.
Item numbers 2, 3, and 4.
ये क्या है? Again, sir.
We read the last part of it.
Lordship, is a matter pertaining to more or less the same issue, that is deduction of cess of 10%.
Issue is different, I think. Says, no doubt, but the provisions of law.
It's under the Mara Autonomous District Council, and it's under the 2018 Act, which was passed by the Mara Autonomous District Council. Lordship, starting with the writ appeal number 2 of 2025,
Last one.
13/3/25 I have.
the last order passed by this Honorable Court on 22nd/10/2025
Which are at the end. Just a minute. Give us a minute. Okay.
Orders have been looked at, 10% have been deducted as cess
From compensation.
for the compensation. They are saying that already 2.5 had already been deducted earlier.
Just 1 second, 1 second. B2 देखना होगा. The executive committee or the concerned authority on its behalf may official order. notification, only one notification is not under challenge. Now this administrative work is something else. Compensation is what? It is with respect to the value of money. Compensation. Therefore, it can be deducted.
It can
Who appears for the respondent?
Your Lordship.
deduction has already been made by the
2.5% is already. Therefore, the maximum is 15%. So they have reduced it to 10% by virtue of this notification. Why don't you challenge the notification itself?
Your Lordship,
No, I am asking him.
No, he's for the
Lordship,
district council.
it's for the writ petitioners.
Yes, she has.
A lordship is, it does not say that it's a, says deduction is not from compensation, land acquisition compensation.
What is
Kindly,
compensation?
it says only from the vendor.
Compensation is calculated on the value of land.
That is correct. A lordship, kindly see section, 2013 Act, LA Act, section 12. Preliminary survey and land and power of officers to carry out survey. For the purposes of enabling the appropriate government to determine the extent of land to be acquired, it shall be lawful for any officer, either generally or specifically authorized by such government, in this behalf and for his servant and workman. A lordship, in my understanding, the government require land for the construction of road. So, Your Lordship, notification was published under section 11. And
This is not for the purposes of, this is not for administrative purposes. This is a cess on the value of land. Compensation is the value of land.
But then the rules say that the cess is for the purpose of
No, cess is not for the purpose. In any
23 G.
22 2,
22 to 20.
man in which it is in 23 2B, to collect and levy cess to the extent of 15% or cost or charges which may be increased or decreased and fixed by the executive committee from time to time by official order or notification from any landholder for the value of land and on any other ground and in the manner as may be. So this is collecting cess to the extent of 15% or cost, or compensation is cost,
Correct.
and then or charges which may be increased or decreased.
Correct. But the cess has to be for a certain purpose.
No, to it can cess is for the administration for further what?
It says
Collect
that
such
it may be
fee.
prescribed for the conduct of government.
To collect and levy cess to the extent of 15% or charges which may be increased or decreased and fixed by the ECA from time to time by official order from any landholder from the value of land and on any other ground and in the manner as may be prescribed from time to time for the conduct of spot verification survey. This for the conduct of spot verification, survey and measurement or any other administrative work or
What is
otherwise.
that the award page?
what date is Your Lordship?
The purpose is there. If you read it, the purpose
Okay,
is there.
sorry.
page 59 to 64.
Page 63, serial 10.
Administrative cost. Now, what is his name?
Lalram Zava, serial Zava. Lalram Zava, Zava is called Zava.
Zava. Mr. Zava,
Lordship,
I come to 23 2B.
23, section 23. Yes,
23 2B.
Lordship.
We need not read the whole of it. Come to 23 2B. Please read it slowly with proper punctuation. Then only
yes.
we will be able to understand.
Let me
Both of
start
us.
from, let me start from the governing
No,
provision.
to collect and levy cess.
All right. to collect and levy cess to the extent of 15% or cost or charges which may be increased or decreased and fixed by the Executive Committee from time to time by official order or notification from any landholder from the value of the land and on any other ground and in the manner as may be prescribed from time to time. For the conduct of spot verification.
From time to time.
From
Now,
time to time.
the statement doesn't end here. Now, it is no, for is an addition. It is not a simple conjunction. It is an addition. Now, this collection and levy of cess to the extent of 15% is for a purpose.
Yes.
For the conduct of a spot verification, survey, and measurement or any other administrative work or otherwise as provided and envisaged under 1 of 22. Now read 1 of 22.
22.1. No land survey, spot verification and measurement over any land allotted to any person by District Council in accordance with the Mara Autonomous District Council Non-Agricultural Land Settlement Act 2011 and the Mara Autonomous District Council Agricultural Land Settlement Act 2011 or any other law enforced in District Council area shall be carried on by any person, governmental or non-governmental department or agency for any purpose except by the District Council.
Right. So
Surplus.
therefore this survey, spot verification, measurement can be done by no other authority. It can be done only by the District Council.
Yes.
Correct?
Yes.
Now, therefore, the question of cess, it is not for the purposes of maintenance of the land, as you saw in the first case. So we agree the value of land could be compensation, no difficulty towards that. But this, levy of cess to the extent of 15% is for a purpose. It is not a general assessment of tax on land, which is permissible to a legislative, to a council, to an autonomous council or to a state, because it is perhaps, I don't know whether autonomous council can have that, unless there is a provision, but it is covered by entry 49 of list 2 of the 7th schedule of the Constitution.
Lordship is thinking in terms of the purpose.
Tax of land.
Yes.
Tax on land. So tax on land could be in the nature of a cess. Now this cess is not as an income from the land. It is for a particular purpose. This is how your act reads.
Yes.
And if we don't read for in between, in the context in which it is done, then perhaps you could have said. Now, but for the fact that you had charged 2.5% for survey, etc., now you can't now say that 10% more, unless you say that it did not cover the purpose.
Yes,
This is only for a purpose. I think your introductory order is good.
Lordship, the purpose for which 2.5%.
Your only ground, Mr. Zaba, is that it cannot be, compensation is equivalent to the value of the land. The
value of the land can be ascertained only at the time of compensation.
See, based on the exemplars in the surrounding area, the market value is assessed, unless you have a separate market value chart that none of the districts have, that no state has. No, or even if it has, it is not updated. That's the phenomenon in all states. Now, therefore, the value is compensation. On that ground, she doesn't succeed. But she succeeds on the very wording of section 22(1)(b), 23(2). That is what
22.
my brother Michael has written in the last order.
Lordship, if I try to satisfy a Lordship, there are four things. There are four things which the writ petitioners ought to have challenged, but which they have failed to challenge. One is that the word, they are not happy with the word, but they have failed to challenge that.
What they have failed to challenge?
A word which is at page 59.
No, why?
No.
Where is the problem?
The problem is that, Your Lordship, here in the summary of the word, at page 63, Lordship will see,
He's saying that he is basically saying
Lordship will see that there is deduction of 10%.
it has been made by the district commissioner, and this is to be made by the district council. Now, deputy commissioner is working
That
for
is
the
a different
district.
argument.
No, he is working for the
Working
district
for the
council.
district. That argument.
Lordship may peruse page 63. It is a chart,
That
summary of
argument
their
leads you
work.
nowhere, Mr. Java.
Lordship.
That argument doesn't lead you anywhere.
And the second thing is the Act of 2018, which we have just read. It has clearly indicated that there's a provision for deduction of cess from the value of the land. And the value of the land needs to be ascertained even at a time of measurement, even at the time of acquisition.
No disputes. We are not disputing this proposition.
All right.
If you had not deducted 2.5% as administrative charges,
And that deduction of
unless you build up your case that this cess is meant for the income from the state, this is under entry 49 list 2. Can you say that?
Lordship,
No, you can't.
deduction of 2.5%. Here, it is shown at page 63 that the total compensation out of that administrative cost of 2.5% is to be deducted. But that deduction has been made by the district authorities, not by the district council.
District authority on behalf. The
No,
district-
not
district
on behalf
council
of the district council.
Where is that ground?
District council, even if it's under the state, it is the district authorities that have made deduction of 2.5%. In fact, deduction is not made from the total amount of compensation
Now
to
let's
be
see.
paid.
Let's see whether it has been done by district commissioner.
No, has
Yes,
to be
Lordship.
done. 63, page 63.
Page.
For the word and that is for a purpose.
Yes.
That has been done.
63 years.
Total cost of compensation payable is this. Administrative cost at the rate of 2.5% of total. अच्छा लिया है 4 lakhs तो ले लिया.
So what we
This
say
is by
is,
district
this has
collector.
been made by the district, but announcement of award has to be done by the district collector. That's all. We try to differentiate between the district collector and the district council. The district council is working for.
If I take a Lordship to
Just a minute. Award देखिए इनका. Start from page 59. Come to page 59. This is the award number 5 of additional 1. ठीक है? Now come to claims. Claims is 0. Market value, structures. Then come to 9. 10% cess as provided by subsection 2 of section 23 of the Mara.
2018, that's what has already been done.
The land's values shall be remitted to the by notification memo number. This has been done. No, this is what has been done.
That is what it is.
This is what has been done. No, तो ये है.
Now this, read with this.
This read with this, तो it has not been done.
It has been
Date
done.
कैसे? As provided by so and so, 10% shall be remitted to the land revenue.
Assess on the value of land by notification memo dated 23/9/19.
23/9/2020.
Where is this 23/9/19 notification? अच्छा, it is here.
कहाँ?
Which page is it?
page 73.
Page
73.
This is not been done.
has not been done. So this makes it very clear. 73.
Page
तो
52.
बहस नहीं करता है.
Collected revenue to the extent of
In
Seven,
accordance-
71.
The Executive Committee of Mara Autonomous Council is pleased to notify for information. Committee of the said Mara Autonomous shall collect and levy the revenue cess to the extent from any land from the value of land on any ground and on any other ground
time to time.
from time to time and for the conduct of and also for the conduct of and also for the conduct of. Now look at this notification and look at this award also. Now read this notification. Read this. So as provided by so and so, land value shall be remitted to the land. So this will be remitted after collecting from whom? District collector.
Yes. But then how did he do this?
Administrative cost he has taken.
Yes.
Now this 10%,
10%.
both of 23B, this is the notification. Mara Autonomous Council said notification. Now the act which we read was this, 23B2. For any other purpose for no, na? Where is that?
Yes, please.
No land surveys, but there is a district council.
23 2B. Next page.
To collect and exercise of the powers vested, it shall collect
To
revenue.
collect and release cess to the
To
spirit
collect
of
and levy, to collect and levy cess to the 15% or cost or charge. तीनों चीजें, levy to the extent of 15% or cost or charge.
whatever. But the purpose for the
No, or charge
which may
or
be
charges which may be increased or decreased and fixed by the executive. Charges may be prescribed in guideline for conduct. But this is to the extent of 15% of cost or charge.
Yes.
So therefore it is cess under the tax or for the purposes. Otherwise this would not have, what is this?
that is there.
What will you do?
Lots
Mr.
of-
Zawal, look at this. Now we are trying to read it. Now you have read 23 2B,
Yes, lots of.
right? We have read for by adding, by super adding this requirement that this cess is for the purposes of spot verification, survey and measurement. But then look at the notification here at page 73.
Yes. May I read the Lordship?
In exercise, let me read it in the manner in which we want to read it. In exercise of power conferred by section 23 subsection 2 of the Mara Autonomous District Council Act 2018, the executive committee of the Mara so-and-so is pleased to notify for information of all concerned that the executive committee of said Mara Autonomous Council shall collect and levy revenue cess to the extent of 10% from any landholder from the value of the land or any from the value of the land and on any other ground that in the manner as may be prescribed from time to time for the conduct of. So it is from the value of the land, 10%
Yes.
from the value of the land. Now come to page 62, which is part of the award. Now let us not go wrong on law, whether it is in your favor or in her favor.
That's true, Your Lordship.
Look at this 9. As provided by subsection 2 of section 23 of the Mara Autonomous Council, 10% of the land value shall be remitted to the Land Revenue Settlement Department as cess on the value of land with effect from so-and-so, wide notification date so-and-so. Therefore, while imposing, we are reading in your favor, Mr. Java, which you have not pointed out to us. So, while the award was being published, the breakup was given 2.5% of the total administrative cost you have deducted, and this has been left open, that 10% of the value shall be remitted. Now who shall remit it? We can read it in two different ways. You can say that this has been left open for the district council to recover from the landholder, or you have
This-
chosen not to do it.
10% will be recovered from the landowner, whereas 2.5% is a super addition.
Mr. Zava,
It's a super addition.
I have given you an outlet, you are not building up on that argument.
Your Lordship, if I'm allowed to, this 10%, what I'd like to submit before Lordship is that this award, having clearly specified for deduction of 10% cess on the basis of the provision of law. Lordship, this has not been challenged
No,
And-
this is. Of.
Secondly, Your Lordship,
Now, this annexure 3 begins at page 59,
yes,
correct?
yes,
This is the award
Award.
number 5, additional 1
one
of
of
2021.
2021, yes,
Now it talks about the introduction, then number 2 is measurement of the true areas, then claims, then market value of the land, then the structures, then crops, then apportionment, then land revenue, and then 10% cess.
Yes.
Under entry 9, under item number 9, para
Yes.
9. Now this says that as provided by so and so, cost you have already collected. This says is by virtue of 23(1)(b) to be recoverable from the landholder only by the district committee from the compensation. Otherwise, how would it be assessed? Look at this. Now, suppose 10% cess were to be taken. Now, the distinction of compensation and land value cannot be made, because if 10% has to be done, it has to be on the amount which the landholder receives. It can't be in air. So therefore compensation is the land value.
That is there.
And therefore this 10% cess is to be recoverable by the district council, which the collector says that this shall be remitted. Followed?
Yes.
Followed?
Shall be remitted. Oh, okay.
Shall be remitted. So this is recoverable by the district council. And in the process, the district commissioner says that I will recover.
Then this has,
Correct.
This has been so this is extra.
What is her name?
Miss Dinari.
Miss?
Dinari.
Ms. Denari, you
Yes.
have understood where the fault line lies?
Yes, I understand that. Your Lordship, beside the section,
Now it's
Your
in a very,
Lordship,
it's in a very.
just
We are
one
not inclined to pass any order today.
I know. Your
For
Lordship,
the reason that we were thinking differently, but suddenly it dawned upon us that
yes,
this can be collected.
yes,
Now this is because we read the award.
yes. Your Lordship, my understanding of the revenue law of the ADC, it says that, Your Lordship, kindly see page 71, section 22, 2.
Twenty-one two.
22, 2.
22 2.
Yes.
Yes.
23 says that, 23(2) says that in exercise of the power vested to it by section 1 of this section and subject to the provision of section 22 of the Act. So, section 22(1) is already read. Section 22(2), in case any land is necessary for any purpose to be surveyed, verified or measured, etc., the owner of the land in question shall apply for the same in writing before the concerned authority, and that the district council and the concerned authority shall perform such required work as and when it deems necessary, and in the manner as it may deem appropriate. In certain case, the concerned authority may.
No.
A Lordship, yes.
You see, one thing.
What I mean to
what the chief is saying
yeah,
is that this clause 9 at page 62.
yes,
See, please just look at this.
yes,
This clause 9 says, as provided by subsection 2 of section 23, 10% of land value shall be remitted
yes,
to the Land Revenue and Settlement Department, MADC Saiha, as cess on the value of the land effect from 19th by notification dated census. Now this award has been pronounced in terms of the provisions of that right to fair compensation.
2013.
No. So this clause 9 is still is a valid clause. this has not been put to challenge.
No. This clause 9 is
Is-
part of the award.
Correct.
It's part of the award.
It's part of the award.
So
Part of the award as per 2019.
which clarifies that this 2.5 is for the purposes, for administrative purposes. This remission would be authorized by the, would be recoverable by the district council, and it shall go in their account. So therefore they are making a distinction while making an award, that this is for this and this cess is for other purpose. This we say for the reason of the notification. And notification, under the act, the notification says, वो हम किस page पर थे? I was at a particular page of the
Page 73.
notification. Page?
72,
73.
73.
This is a cess on the land
Yes.
or and on any other ground. Now here if there is some change in the wordings. From for the conduct it says and on any other ground. Here also there is and.
There's
Both the places there is and. So therefore it is not necessarily to be taken as cess for the purposes of administrative reasons, for the cost of survey, etc.
Lordship, here, kindly see section 3.
Give her some more time to file, to decide. Give her some more time. Yes, she loses in this. You have followed? You have followed?
that this is the.
This internal. आप कहें तो मैं लिखा दूँ. We conclude. Conclude करें. No point here, no?
Yes, clause 9 is the problem.
Lordship,
Page
my
62.
understanding that this clause.
No, your understanding is not very off the line. Your understanding is good. But then we are understanding it in a different way. It is not off the line, let me tell you,
Yes.
Madam Denara. You have rightly argued. But then, because of the... because-
Lordship, in the 2013 Act, Section 3 says that in land acquisition, the cost of acquisition includes, here it's mentioned that Section 3, Clause I, kindly see I. Cost of acquisition includes. Here it says amount of compensation, cost of acquisition of land and building. Here administrative costs also there.
You see, on facts,
Yes.
you might be correct, you're correct. But the problem is this clause read with the notification, this clause 9. Now, what has the single judge said about this clause?
It says that it's not
Did the
mention-
single judge
Yeah.
refer to this clause?
No, not at all.
it says that it's not mentioned for the compensation, from the compensation.
No, did it make any, did it consider this clause?
No,
then?
no.
Para 14. Para 14 of the judgment, Your Lordship.
No, it's not mentioned. You're correct with this 9.
Section 14, I mean, para 14.
And where is that deduction of 10%? By which notification have you deducted 10%?
Yes,
10% is to be deducted by the, on the basis of this notification,
Page 73.
page 73.
No. This is the page 73 is the notification.
Yes.
Where has it been deducted?
Where is the actual deduction?
Actual deduction,
deducted is
the moment was remitted, Your Lordship.
You all deducted it from the.
Yes.
In this
Once it is
particular
deposited-
case, Your Lordship, it's already released to the petitioners.
Or 10% less has been received.
It's not remitted to the MADC. It's in terms of the
They have deducted
learned
it.
single
They have
judge
already
order.
deducted it. While creating the award, they have deducted it. And but it is not shown in this account.
So you all got the full amount or you deducted amount?
Full, deducted, the full amount, after that, deducted the amount, 10%.
They deducted
Cess
it?
also.
They've taken it.
Oh, yeah.
Last year, we have
I'm not
already
definitely-
received.
Now look at item number 3 at page 63. Will be deducted, they say.
Will be deducted, yes.
Summary of the award is this, will be deducted. So they are also taking it differently. It can be read differently. That order is not under challenge. That was my first view. Karna hai? Conclude karna hai? The short issue, madam, you are losing this case. We are allowing the appeal. We are allowing the appeal. We have heard but you have done a good job, but then ultimately we have heard Mr. C. Lal Ram Zava, learned senior advocate for the appellant state, and MS
MADC. Lots.
for MADC,
Yes.
and MS Dinari T. Aziu for the respondents. This appeal has been filed on a short point whether deduction of 10% cess from the award, from the compensation paid to the respondents is justified. The learned single judge has submitted that once the administrative cost at the rate of 2.5% of the total value of the land was already realized from the respondents, 10% cess could not have been levied on the respondents' landholders. That apart, it was held that there is nothing in the act or the rules governing the field which would justify deduction of cess from the compensation, as in any circumstance it is deductible from the value of the land. To state the facts in short compass, for a proper understanding of this appeal, it is stated that the respondents were owners of the land through which a road was constructed, but the respondents were not paid any compensation. They approached this court by WPC number 160 of 2016 and WPC number 224 of 2016, wherein a direction was issued to the appellants herein to conduct a spot verification to find out whether the road had been constructed through the land of the respondents, and if it was, to prepare a supplementary award for acquisition of land of the respondents. Though pursuant to the orders, verification was done and an assessment was made, but it was only with respect to a small portion of the road which was constructed, that is only for 20 kilometers. and therefore the names of the respondents did not figure in that assessment. First up. The respondents therefore had again to file a writ petition before this court by WPC number 53 of 2017, which was decided on 2/5/2008, directing the respondents to invoke the provision of right to fair compensation and transparency in Land Acquisition, Rehabilitation and Resettlement Act of 2013, hereinafter called the Act of 2013, to assess the compensation payable to the respondents, and if they wanted to vacate the land of the respondents, to pay them damages within a time frame. First up. Pursuant thereto, the award was prepared, but 10% of the cost of the land was deducted towards cess. First up. The respondents challenged the aforementioned deduction along with other grievances which were allowed, but the present appeal deals only with the decision of the learned single judge in not sustaining the deduction of 10% of the cost of the land towards cess on twin ground of there being no provision for deduction from the compensation of the land, which might not always be akin to the cost of the land, and that such recoverable cess was only for the purposes of administrative expenses which had already been taken care of by deducting 2.5% by way of administrative charges, which fact is amply demonstrated by the summary of the award. By the summary of the award kept at page 63 of the records of this appeal. So we have heard the after having heard the learned counsel for the parties, we have also examined the relevant provisions of the Mara Autonomous District Council (Land and Revenue Act 2018). Sections 22 and 23 of the aforenoted Act of 2018 is being extracted herein for the sake of completeness. Extracted from this is, you can take it from the order dated 22/10/2025, passed by my brother. From the order, extract the whole of it. Stop. A bare reading of section 23 2B provides that to collect and levy cess to the extent of 15%, then write or in italics or bold, or costs, then again or italics or bold, italics and bold, or charges which may be increased or decreased and fixed by the executive committee from time to time by official order or notification from any landholder from the value of the land, and then what I am dictating, you have to do it bold and italics, and on any other ground, you have to underline this, and on any other ground, then and in the manner as may be prescribed from time to time for the conduct of spot verification, survey and measurement, or any other administrative work or otherwise, as provided and envisaged under section 22 of the Act on certain and special occasions as the case may be. Full stop. This therefore clearly demonstrates that there could be levy of cess to the extent of 15%, which could be varied or by way of cost or by way of charge, and such power to cess levy would also be for the for other grounds like conduct of spot verification, survey and measurement, and for other administrative works. Full stop. Thus this cess, thus this levy of cess could be as a tax on the land, comma, money recovered for covering the administrative expenses, or any other purpose in consonance with section 22 of the Act of 2018. Of the Act of 2018, no? Of the Act of the Act of 2018. First up. We have also gone through the award number 5, additional 1 of 2021, which, after taking into account the circumstances under which the additional award was prepared, takes into account the market value of the land, takes into account the claims of the respondents, the market value of the land, the structures appurtenant to the land so acquired, comma, the standing crops, trees, etc., comma, the apportionment of award, as also 10% cess, which was remitted to the Land Revenue and Settlement Department, MADC Siaha, as cess on the value of the land with effect from 19/9/2019, vide notification memo number so and so dated 23/9/2019. First up. The learned single judge, therefore, was not correct, with utmost humility at our command. We say that the learned single judge was not justified in ruling that once administrative cost at the rate of 2.5% of the total value of land had already been deducted, comma, the cess recoverable on the value of land could not have been levied, as such levy was only for the purposes of covering administrative expenses. Full stop. This is only a partial reading of the provision contained in section 23 2B.
Lordship, may I, the judgment is discussed in paragraph 14, is with regard to the cess.
We have seen that.
Yes.
We have seen that. So far as the reasoning of the learned single judge that no cess is recoverable from the amount of compensation awarded is not sustainable in the eyes of law, as compensation is on the basis of the market value of the land, which otherwise could not have been recoverable unless compensation was paid to the landholders / respondents. For the aforementioned reasons, we do not find that on the issue raised in this appeal, comma, the reasoning given by the learned single judge was justified. We therefore set aside the same and direct that the appellant MADC shall be under no obligation to refund the amount of 10% levied on the landholders as cess under 23(2)(b) of the Act of 2018. The appeal stands allowed to the extent indicated above.
Lordship, it has been stated at the bar that it has already been refunded. Even if it is refunded, it can be recoverable.
In case the money has been refunded pursuant to the judgment of the learned single judge, that
That
shall
is
be
their own, beyond their pleadings, Your Lordship.
that shall be recoverable after following the due process of law.
I know this.
Yes.
Lordship, the other two are covered by the first one.
What does it say?
The same. The other cases are, yes. All the cases are covered.
Yes.
Same order.
Same order. और तीनों को एक साथ लिखा था.
Item 5.
बहुत लंबा समय लग गया. कल से कम रखिएगा.
My Lord, in pursuance of the order passed
You're
by...
appearing. Where is your file? You can't argue like this, no? चलो इसको भी कर देते हैं. Yes.
Lordship, the respondents have received the notice and we have not filed our power yet. We will be filing our power.
You have not yet filed your power.
Not yet.
But we permit you to argue if you are ready.
Argue?
If you are ready, we permit you.
Not yet.
We'll say that you will file the power sometimes later in the registry. Who can be so indulgent but for us?
If this matter may be listed on Thursday, Lordship.
No.
No, not.
Therefore, you were not ready with your file.
Not yet. Lordship.
Tomorrow?
Tomorrow, Lordship.
Huh?
Tomorrow, file your power in the registry.
Tomorrow.
Tomorrow we'll hear you. All right? Let us dispose of cases as far as possible. Tomorrow we say लिखिए. There. What is your name?
Stephen Lalbuatsaya.
Take down his name. Mr. So-and-so has appeared on behalf of the respondents and has submitted that he shall be filing his wakalat. What do you say here? Power. I call it wakalatnama. He will be filing his wakalatnama on behalf of the respective respondents by today in the registry. First up, let this matter come up for consideration tomorrow. Tomorrow mat likhna, date likhoge. Yes.
Fourth. Item number 6.
It's also same matter, my Lord.
Same, both the matters tomorrow.
My Lord. Obliged.
Item 7.
Bring all the judgments that you will be relying upon, Mr.
Yes, my Lord.
Item 7.
Airport.
Yes, man.
हाथ टूट जाएगा उसको निकाल के दो.
We can ask for the status.
Last order क्या है? What is this for?
Construction of the airport.
Last order dated? Uncomfortable chair है ये. Let's do
8/10/25.
8/10/25. Give us the order dated 8/10/25. Somebody has to come here and navigate. Michael, you
You have to file your affidavits.
So, no, my Lord, let me
What was the case about?
This is the
Original case? What was the prayer? What has happened up till now?
this is the original. To do this first.
Who is respondent number 6?
Who is respondent number 6?
There are two contractors in the airport, my lord.
5 and 6.
5 and 6.
Okay, 6.
Six
Somebody is
newly-
appearing for respondent number 5. I am appearing. And who appears for respondent number 6?
My lord, respondent number 6 is unrepresented.
No, there is nobody.
Nobody, my lord.
He's from Mysore.
He's from Aizawl. We took steps by way of Dusty, my lord, so two times. As in fact, in the last court's order, it's reflected, my lord, that this matter will be proceeded without in his absence.
What is this restricted tender?
So, my lord, for the restricted tender is for renovation of the airport, my lord. So steps were taken for renovation of the airport. So there was a restricted tender in this respect, my lord.
That's what we are asking. What does restricted tender mean?
So, my lord, according to them, the restricted tender has been issued because the work involved, my lord, there involves some kind of expertise, and that it requires work to be done in great speed and all that, my lord. So because of that, they had issued a restricted tender.
So open tender is not.
It's not an open
so
tender.
it restricts the number of contractors. that
Correct.
can appear,
It restricts the
depending
number
on
of
the
contractors.
Sure. Bank accounts.
What is the current status of the who has to the some officer, the contractors can't say, they'll say who are the officers?
The PWD, I think. PWD is doing it.
Party position देखें जरा यहाँ. Show me the original the petition, PIL petition. Just come to it.
This is a
There is
PIL.
a way of
Yes,
filing.
my lord, as per the last
Orders,
affidavit which they
when
submitted.
Orders are so many, keep it in a separate docket, and the main petition should be there. So every time it will be difficult, no? These are all additional affidavits. These are all additional affidavits.
My lord, as per the last affidavit,
Memo of parties also will do. It's only affidavit, no? I tried to look for it in the morning. I couldn't, so I just left it.
What is the status right now? Affidavits have to be filed.
yes, so my lord, as per the last affidavit, which was on 4th March 2025, they had mentioned that 98% of the work has been completed.
इसका इनका खाने से मैं ऑफिसर को बुला के पूछे who is the other file want the party position.
Who's which office?
Principal consultant. Respondent number 3. Respondent number 3 and Secretary to the Government of Mizoram, PWD. Who appears for respondents number 2 and 3?
I am appearing, Your Lordship.
You should have said that. You should have volunteered. You appear for the Secretary to the Government of Mizoram?
Yes, Your
PWD.
Lordship.
Now,
Yes.
what is your information about it?
Your
What has
Lordship,
been done up till now? What is the status report? The updated report till yesterday.
Your Lordship, at the onset, I would like to state that the case is being handled by Mrs. Mary, who's on legs in the other courtroom.
That's none
However,
of the concern.
yes, Your Lordship, and the information that I have gathered from her is that there is a checkpoint which has to be constructed.
There is a
Checkpoint which has to be constructed, Your Lordship. Check-in that has to be constructed.
checkpoint is a very
check-in-
small thing.
Yes, Your Lordship. So they have to shift the staff from the first.
Look at this. You have received instructions from another council, right?
Yes, Your Lordship.
And you are talking to a judge. Both of us, we were there at the airport last afternoon. So our information is more correct. Absolutely updated.
Yes, Your Lordship.
Checkpoint is not a big thing. That can be done within a couple of days. The
Yes,
issue
sir.
is something different. Now we don't want such piecemeal, information.
Understood, Your
Where
Lordship.
is the lawyer who represents 2 and 3? We
Your-
are not concerned with 5 and 6. 6 has not come. Whether he has been blacklisted.
He has not.
He has been blacklisted.
No, he has not been.
Has money been recovered? Has there been an audit that he has not wrongly been paid? You have no idea. How do we
Your
deal with
Lordship-
the matter?
Your Lordship, if I may be given another time,
Another time.
Your Lordship, if the matter may be heard again after some time because the counsel is in the other courtroom, Your Lordship. He's on legs in the other courtroom.
Counsel is in the other courtroom. We can hear. She will not be able to say anything. Now, you know what you have to tell to the counsel? That the court is asking for up-to-date reports.
Yes, Your Lordship. Officially, we have not been given up-to-date report. However, there's
That
only
is not
verbal.
an answer. That answer would be good for you as an advocate.
Yes, Your
But
Lordship.
that answer is not good for the respondent. Who shall give him the report? He is the person who is to collate the report and tell us. Adjunct.
The status report is given on Friday by the freedom.
There are fresh
Madam, I think the PWD has to buckle up a little bit, and also the contractor. Where is he right now? He's here in Aizawl. You give a status. Both of you give a status report within 2 days. File it by Thursday. We'll list it on Friday. We'll take it up on Friday. Okay. Okay. Miss Lalnun Lui appearing for the respondent number 2 and 3.
2, 3 and 4, Your Lordship.
2, 3 and 4. And Mr. Lan Rokong appearing for respondent number 5. Shall file an up-to-date status report within 2 days. You give a status, both of you. Oh, who is there? Yes. You file
My
a
lord,
status
I'm
report.
hearing for respondent number 5. My junior is there.
And then we have mentioned his name. So list the matter on Friday. Look, you have got to buckle up. Huh? We are going to monitor it slightly seriously. from
And
now.
we would also like to know what action has been taken against respondent number 6. He is not. We can always ensure his presence. Mr. Warrant of arrestation. Available warrant of arrestation. Ask him. You are another contractor. Tell him that if he doesn't appear on the next date, we will issue bailable warrant of arrest, and if he doesn't appear, then we will have him arrested and brought here. We don't want to be very harsh on the first day of my visit here.
Obliged, Lordship.
Friday. My
Friday.
brother will issue warrant of arrest against him.
Just say one thing. As per the affidavit file, dusty notice has apparently been served upon the respondent number 6. Still, the respondent number 6, the second contractor, is not present in the court.
Item 8.
This is also again airport.
This is
No, my lord.
Aizawl to Mumbai, South Mizoram. Again, this is now 2 years old, I think.
Yes, my lord. My lord, the road is so very bad till date. They have not, even they diverted the money for constructions of the road also. If you see the last court order, it is very clear.
इसको भी लगवाइए Friday को updated report.
Yes, madam.
Your Lordship, in this, I'm representing the state respondent, that is 1 to 7, and we are yet to receive information regarding the same.
You
Lordship.
tell the engineer in chief that he has to file a status report within 2 days.
Yes, Your Lordship.
Okay. Right, Miss Lalman Dui, Land Council appearing for respondent number
1 to 7, Your Lordship.
1 to 7 shall ensure that a status report is filed by the engineer in chief PWD with regard to the Aizawl, Thainzawl, Lunglei Road. List the
My lord,
matter
my
on
name, my presence may kindly be reflected.
Mr. Spencer J.C. Laram, JC case for respondent number? For the petitioner?
I'm for the petitioner,
For the
Lordship.
petitioner.
Item 11.
This is again Aizawl Korasip Silchar Road. What's happening here?
Your Lordships, I'm appearing on behalf of the state respondents 1 to 5.
Today your senior has left you in the middle of the stream, knowing nowhere to which way to swim.
Your Lordship, in this particular case, I am well versed with the case as much as possible, Your Lordship. So, if I may be allowed to make a slight submission that I have received the pairwise comments. However, the submissions are very technical. They've given like a chart. So, as lawyers, we're not able to understand why the chart has been given.
How can you tell
Yes,
this
sir.
about lawyers?
Yes, Your Lordship.
You can talk about yourself, not lawyers. Lawyers are experts of all experts.
Your Lordship, the technical submission is, so we have asked for a meeting.
You can pass on that. We will try.
Yes, Your Lordship.
Right. You have it with you?
Yes, Your Lordship. But
put it on record.
It is not yet vetted.
Put it on record by way of an affidavit. We will try and understand what the respondent wishes to communicate to us.
Yes, Your Lordship.
What time?
If I may be...
इनका नाम क्या है?
Lalnun Hui.
लालनुन हुई. MS Lalnun Hui, learned government advocate, for response number 1 to 5, submits that she has received instructions and that she would put it on record by the next date. Re-notify on, give a date sometimes next week. 2 weeks.
19th of November.
Obliged, Lord.
Item 12.
This can be listed for hearing because paper book has been made.
May it please your Lordship, I'm appearing on behalf of my senior Mr. Johnny who is absent today. Lordship, if this matter may be taken after...
You should have mentioned in the morning, no? You should have mentioned in the morning. The rubric, wrong heading does not deter us from hearing. Now, if there are lesser matters, we can hear it today if you are ready. You're not?
Not ready, Your Lordship.
All of you will have to come to Guwahati one day or the other, either virtually or physically. Now we will make you work. Here also you work. I'm not saying that, but be ready. When your Chief Justice comes, you be ready in all cases. So that I go back with good memories.
Apologies, Lordship.
I go back with good memories, with a longing to come back to you again. Let this be listed for here. Paper book is ready.
Book is ready, Lordship.
Do you know what is the conviction for?
Pardon, Lordship?
What is the conviction for? In which sections, in which act the conviction has been recorded?
22C.
In this particular
Yes,
case,
yes.
it's section 415, subsection 2 of the PNS. Sorry, Lordship, 22C
Of
the
what?
NDNPS.
Of
the NDNPS Act.
NDPS Act.
Yes, Lordship.
And what was recovered?
14.55 kgs of meth.
55 kgs of?
Methamphetamine.
You're in practice for how many years?
Lordship, 3 years running.
It's good time for you to get ready in criminal appeals.
Lordship.
There's a very limited aperture in which these appeals can be heard, Anyway, since the paper book is ready, the appeal be listed for hearing. Be listed for final hearing and disposal on, give a date? After a week.
Obliged.
Hearing
12.